Good morning to all of you. We are going to discuss a case law on the MV Act, or that is relating to compensation, as well as the Limitation Act, Section 5 of the Limitation Act. Actually, more thrust is given on Section 5 of the Limitation Act. That means condonation of the delay. If you are able to convince the court that you have got valid reason for not filing the petition in the particular time and request for the condonation delay, it can be accepted by the court according to Section 5 of the Limitation Act. But here, in this particular case, the courts emphasized the need of the MV Act. It says that MV Act is a beneficial legislation and people should be given one more opportunity. Right. While disposing the case of Koppula Rajasekhara Raja, alias Koppula Rajasekhara alias Raju versus Srimati Aruna Sharma. So, 2021 decided in civil revision petition. It's a revision petition, maybe under section 115 of the Civil Procedure Code. So, civil revision petition number 648 by 2020, and this judgment was delivered on 27/11/2020. So, the main points in this is, please remember, let's know the details of the case first. So, it so happened that actually this is a claim petition for compensation under the Motor Vehicles Act before the Motor Vehicles Claims Tribunal under section 166 of the MV Act, and also Rule 475 of the MV Rules, APME Rules 1989. Here what happened is, on the incident took place LB Nagar, yes, on 16/5/2013, on 16/5/2013 at about 9:30 p.m. So while the complainant or the appellant here, the revision petitioner, Mr. Koppula Rajasekhara, was going on his motorcycle in LB Nagar area, and due to the rash and negligent driving of the crime lorry, then his left leg was totally fractured and it has to be amputated, and there is a shortening of expectation of life also. So the doctor said he could not go for any work till 1 year. So he has sustained heavy loss. So therefore he filed a claim for compensation. Right. This was taken as MVOP number 833 by 2013 under section, as I already told you, 166 of the MV Act, and roll number 475 of the APME rules by 7th ADJ, Rangareddy district. Of course, 7th ADJ is also in charge of SC/ST cases. Okay, right. So he filed the petition, but normally notices will be given to the driver, the owner, the insurance company, all these things. But incidentally, when the matter is being posted on a particular date as a last chance, he was not present. So the court gave the order on 15/2/2017 like this: no representation, even though it is passed as the last chance. So even though the court stated as the last chance, no representation from the claimant or from his advocate. Petitioner called absent. So MVOP is dismissed. So this is what is called dismissed for default. So poor man, the case has not at all come up for trial. At the stage of admission, before the trial itself, it was dismissed. Right. So actually this is on 15/2/2000. On 2/6/2017, same thing. Notice served against R2, counsel for the petitioner called absent, no representation, process not paid to R1 within the stipulated time, hence petition is alright, almost similar lines. Now we can conclude that the petition is dismissed. So aggrieved by this dismissal petition, the petitioner approached the Honorable High Court of Telangana in IN number 750 by 2018. So requesting to condone the delay of 369 days. So for revision, it has taken almost 1 year, 369 days. So, right. So the grounds he has told is, on that particular day, our claimant, Mr. Rajasekhara Raju, he has to attend the funeral of one of his relatives. He informed them the same to the advocate. But what happened to the advocate is the advocate was held up in the traffic due to which he could not represent the matter in the court and therefore the matter was dismissed. Already, please remember, he lost his leg and he was suffering for livelihood. Already he was amputated below the knee. Right? He could not be able to attend for his duties for 1 more year. So this is the pathetic condition. Added to this, his petition is dismissed. Actually, he claimed for 30 lakhs. Right? Now, when the matter has given before the court, now the observation of the court is important. So it is a beneficial legislation. So due to the accident, he lost his leg and also his livelihood. Right? Though the impugned order discloses that he was given sufficient opportunity and since he could not attend, it was dismissed for default. But please remember, since Motor Vehicle Act is a beneficial legislation and the benefit should be given to the petitioner who is already injured, and one more opportunity may be given to him to proceed further. So one more opportunity may be given to him. The courts below shall not deny the compensation on technicalities. After all, he could not attend the court and on a particular day it is dismissed. But it should not be on. So if he is not able to produce the witnesses or if he is not able to produce any documentary evidence, fine. Yes, you can dismiss the case. So already the petitioner suffered amputation and others in the accident case due to the rash and negligent driving of the crime lorry, and this court is also not doing justice to him. Therefore, it is not proper. Hence, the High Court ordered the petitioner can be given one more opportunity to represent the case, and the petitioner cannot be suffered for the mistake committed by his counsel. That's why at the time of the so-called content of the courts, or when this the Limitation Act will tell you that due to the negligence of the advocate this happened, and court will definitely accept the same. Ultimately, the parties are directed to appear before the court on 24/12/2020, and the petitioner is directed to file the material documents along with the CRPC and CRP, and the court may take decision on this part. That means he may be allowed. So, good case regarding the continuation of delay. Please remember it. If you find time, you can read it through ALT, page number 579 or so. It will be useful for you. Thank you very much.